Well, I hope you're all having a great Monday. My name is Bob Bianchi. Welcome back to the Law and Crime Network. We are in the trial of Derek Chauvin. As you know, covering it gavel to gavel as we do here at the Law and Crime Network. We're in jury selection. There are 8 jurors selected out of the 14 that are needed. Let's go live to court.
To make sure that you are heard. First of all, you filled out the questionnaire. Thank you so much for taking the time to do that and to submit it to us. There's a lot of good information in there for the lawyers to ask you about. First of all, is everything true on the questionnaire?
Yes.
And any changes or additions to the questionnaire that you can think of right now?
No.
All right. The questionnaire did advise you not to read any articles, avoid any media about this, but we recognized back in December when you filled this out, or January, that time has passed. You inadvertently may have been exposed to some information about this case. For example, maybe seen a headline in passing, or a friend or relatives talks to you about the case, and we told you don't tell anybody you're a juror, so you couldn't exactly stop people from doing that. Have you learned anything about this case since December and as you sit here today?
No. I've chosen to avoid it as much as possible.
Okay, great. So nothing about not only the facts of the case, but about maybe the parties, any related litigation, anything like that?
No.
Okay. Any pretrial matters, anything about the case or the procedures that have been around the case?
No.
Okay, excellent. The whole point is, as a juror, you have to decide this case only on the evidence that you hear in the courtroom, apply the law as I give it to you. And so while everybody has heard something about the case, to varying degrees, do you think you could do that, is put aside anything you may have heard or seen about this case and decide the case just on what you hear in the courtroom and apply the law just that I give to you?
Yes, I do.
Okay. All right. You were given a list of witnesses. Anybody look familiar on that list?
No.
All right. All right. We had an estimate of trial of 4 weeks, basically. And I think you had some concerns about the length of the trial. Can you tell me about those?
Just for my work purposes, just to let my employers know how long I'm be done, and because I am working on some projects right now, just how to deal with those without causing questions upon my colleagues is where I'm at.
Okay. And you mentioned financial, it might be hard for you. Have you found out, does your employer pay you for jury duty?
Yeah, that's all taken care of and
Okay.
addressed, so I don't have to worry about that anymore.
All right, so that's not a concern. It's more the substance of your work. And
Correct.
do you think you might be trying to do some work after hours to?
Yes, I've had long discussions with my employer just to be prepared, and we've already worked out the working agreement, so I'm good.
Okay. All right. And when asked whether you weren't sure you wanted to be on the jury, and you noted some, do you have concerns for your personal safety?
I do for afterwards, because I know
Okay.
then it will be a public information, and it really depends on how the trial, the end result is, and I, being as this is new to me, I just don't know what I'm to be facing.
Right.
And just want to be prepared.
Okay, and you understand that you are anonymous at this point.
Correct.
Will remain so through the trial. At some point in the future, and not even immediately after the verdict, that's up to me to determine on when it's appropriate to do so. I would, your name will become public, a part of the public record. That doesn't mean you have to talk to anybody, but it could become part of the public record.
Correct.
Knowing all that, do you think you could decide this case and not, without worrying, well, I better come to this verdict or this verdict, because otherwise I might be in trouble?
The verdict isn't the real answer, it's the fact of how people perceive it, because everybody's going to perceive it differently based on the outcome. It helps me to know that it's not going to be public right away, because hopefully some time will have passed before it's public and everybody will move on.
Right. Okay, great. I'm sure the lawyers will probably follow up on that as well.
Correct.
Do you have any questions before I turn you over to the attorneys?
No.
All right. Mr. Nelson, as to juror number 55, you may inquire.
Good morning, ma'am.
Good morning.
What I'd like to do here this morning is ask you some kind of general, broader questions about yourself, about your experiences, and then focus into some of the questions that you answered on the questionnaire.
Okay.
All right? So, assume you and I met under a different circumstance at a social event or a party, and we're engaged in a conversation. What are a couple of things I'm going to walk away knowing about you after that conversation?
Depends on the topic of conversation, of course. I'm a single parent. I work in the healthcare field. I sell Pampered Chef as a side hobby. Those are the main things I talk about with people.
Okay. And you have 2 children, right?
Correct.
And one's older and one's in her teens or his teens?
Correct.
Okay. When you, at some point, you learned that you were a prospective juror in this particular case, right? What was your initial reaction to learning that you were being called in this particular case?
Being as it's my first time, I thought, wow, first time on such a big case, kind of a thrill and caution at the same time, because with everything going on in the world now, you just never know how things are perceived. And my first reaction is I'm going to do the best I can if chosen, because that would be how things work out. I'm going to give my best opinion and make the case very fair.
Okay, great. Can you think of a situation in your personal or professional life where you've been required to sort of step in and resolve a conflict between 2 people?
In my current role, I do that quite often.
Okay.
I work a lot with the patients. If there's patient issues, I'm usually one of the first people out there to deal with the patient and help resolve the issues that they are dealing with our particular clinic.
Okay. And so when you're involved in that kind of a process, how do you approach the resolution of conflict? What are some tools you bring to that?
Well, first is listening. You have to listen to everything. Sometimes they just need to vent, and then you pretty much have to figure out what is their main issue and try to resolve it and see if I can resolve it within my means. If not, I'll do my best to come up with a win-win for both of us.
Okay. Now you understand that, I guess in the context of being a juror, that's ultimately what part of what your role is conflict resolution, right?
Correct.
There's obviously a conflict between the parties in this case, as well as there may be conflict that arises in the jury room.
Correct.
Okay. So if you were, let me ask you this, if you were in the jury room and a particular piece of information comes out in trial, right? And one group of people is really, they think they're adamant that this is the most important piece of evidence. Another group of people is saying, well, that may not be as relevant. How do you approach that situation?
I would have to be neutral, and I have to give each group the opportunity to show why they feel that way, and yet, after hearing both parties, come up with my own resolution and say, well, what about this? Because I'm going to have to share my opinion at some point in time. But being able to hear both parties, a lot of times that's all they want to know. And then it's a matter of you trying to bring out things that, well, I'm questioning this. Why are you saying this? And why are you saying this? And maybe even possibly have some insight from both parties on different ways of looking at things.
So listening to both sides of the story is an important factor, and looking at what other information may support one side or the other is an important
Correct.
factor. Okay. How about in your personal or professional life, a situation where you have been called upon to determine who's telling the truth about a certain circumstance?
I would say more in my professional, I deal with this more, but it's a matter of gathering the facts. And I'm hoping I will be presented the facts to know how to make that decision.
Okay. Can you think of a situation in your life where you were 100% certain of something, you'd formed an opinion, only to later learn that you were wrong?
Nothing comes to mind. Sorry.
Recognize it's a possibility.
Oh yes.
Okay.
Always.
Would you be the type of person who learns from and tries to apply that to similar situations in the future, or would you be the person kind of brushes it off and says, mistakes happen?
I'd use it as a learning opportunity for sure.
Going back to the the situation, let's put yourself back in that jury deliberation room, and rather than being two sort of competing factions over a piece of evidence, you are now...
Okay, so as we go forward with this jury selection, let's bring in the two guests that we have today. Really interesting skill sets. I'm excited to speak with them. Michelle Simpson Tuegel started her career practicing criminal defense, tried many high-profile cases, including capital murder cases and kidnapping, arson, federal felony drug cases, TV and print media legal analyst from CNN to USA Today, and also a jury consultant, very interesting. And Dr. Nadim Karim is a forensic psychologist and criminologist out of Los Angeles, California. He's the director of a psychology corporation with over 7,000 psychological evaluations of adult and youth offenders. It's unbelievable. But what I really love about what Doc's got for us here is that he works on alternatives to incarceration, policing initiatives, and has also been a consultant to various law enforcement agencies in California. So let me go to you first, Michelle. What do you think so far about these questions that the defense asks about conflict resolution, and this particular juror about her responses? Is this a good state juror or a defense juror in your mind?
That's a tough one. I mean, back when I did criminal defense and both consulting with people who are trying these cases, I see someone who seems like she's trying to come across as very fair, and that she is someone who will really wait until she hears all the facts to make a decision, that she's kind of prepared her employer for potentially serving on this jury, and someone who I feel an air of someone who wants to be on this jury, which as a defense lawyer, when I tried these cases, always concerned me. And sometimes that concerns the prosecution and the state as well.
Yeah, I felt the same way with the juries that I picked. Doc, love having you on because you've also, in your bio, have conflict resolution with regard to police officers and their training. How does this juror, in your mind, fit in as a criminologist, pro-defense or pro-prosecution in your mind?
Well, that's an interesting question, Bob, and I think that the bottom line would be to weigh this juror's intelligence on her ability to, as we're saying, wanting to be on the jury. Because the key question is this: from a psychological perspective, as a forensic psychologist, what you're looking at for a law enforcement officer is to determine, in this case, whether or not this officer created an unreasonable risk and whether he consciously takes chances or took a chance to create great bodily harm. So for a juror who's eager to get on this jury panel, she's going to have to be able to be patient enough to weigh the intelligence factor and understand the legal direction that's being given to her to merge the two. So does she have the ability, as eager as she is, to really listen to and understand that what we're looking for here are words that law enforcement takes very, very seriously, and that is a reasonable officer. And in this case, quite frankly, was he unreasonable? Did he take that unreasonable risk? And ultimately, did he consciously take the chance to subsequently create bodily harm and, in this case, cause death? So this juror is going to have a tough time if she's so eager in that regard, Bob.
Well, thank you. Listen, guys, we have two great experts here, a lawyer who's a jury consultant and a forensic psychologist that deals with police matters. We're really going to get into the thick of what's important in terms of picking a jury right after this break. Okay, special treat alert. We have our very own reporter, Kim Johnson, who is on the scene and be giving us great commentary. Just to update you, some really bad answers, Kim, coming from one of those jurors who has a negative opinion of Chauvin and indicated that it seemed that he didn't care about George Floyd. So this is the kind of stuff we're getting out there, Kim. Tell us what's happening on your end.
Yeah, that's exactly the challenges that the defense faced all last week and continue to face today, is finding a jury who hasn't already had a strong opinion made up in their mind. Jury selection, though, does continue today, even after the defense asked the court to pause, claiming last week's publicity of a wrongful death lawsuit and settlement makes it impossible to find an impartial jury. And the consequences of news of that settlement have already been made clear this morning. The very first juror questioned today immediately admitted to hearing about the settlement on the radio Friday. She said that she assumed the city settled because they couldn't prove its case in court. And she also thinks that she couldn't be a fair juror. Take a listen to what she told Judge Peter Cahill.
When I heard that, I almost gasped the amount.
Okay.
And so I would like to think of myself as somebody who tries to be impartial, but I've just been exposed to so much information. And when that happened, it leaned me so far to one side over the other that I couldn't say under oath that I'd be able to take that out of my mind.
Okay. And I've often said to jurors, you know, you're not a failure as a juror if you say this is not a case where I can be fair and impartial. It's as long as it's an honest answer. Do you think that would be your honest answer?
Sir, with there's two officers that I wouldn't recognize by name. In those cases, I think I could come in and say, I truly believe I could be truly neutral. With this particular officer in particular, I'm unfortunately, honestly, I don't think I could be, to be honest.
All right. I'm going to excuse you from this panel, so I appreciate your honesty and your candor on this. There was a lot of other information we might have gone over, but I think...
I am sorry, because this is something I think is historical and important, but I also feel like everybody deserves a fair and impartial jury, and I have to be honest that maybe the other officers, like I said, I'd be more than willing.
Okay.
But I just think my mind is made up.
Now, while the court excused that potential juror, it did seat another. We now have 8 jurors seated in the murder trial for Derek Chauvin. The latest juror is a black man in his 30s. He works in the banking industry, like sports and music. He said that he didn't think that Derek Chauvin set out to murder anyone that day. He also said that he does support Black Lives Matter, and he questioned why the other 3 officers didn't step in. So to recap, the makeup of the jury, we have 4 jurors who are white, 2 are black, 1 is Hispanic, and 1 is of mixed race. 6 of the jurors are men, 2 are women. So 8 down, we have 6 more needed for a jury of 14, 2 of those being alternates.
All right, Kim, great job. We really appreciate it. And folks, we're going to go back into court because there's further questioning of one of those other jurors. Let's go to it.
Okay. So you just thought that more officers showed up. They kind of harassed the kid, or young man, I should say, and it was an unnecessary police response. Would that be a fair summary?
I would agree, yes.
Is there anything about that situation that would affect your view of this case? Like, would you say, you know, so many officers showed up on this case?
I wouldn't know that. I only know what that little clip showed me. I don't even know how many officers were there, how many showed up. I'm just witnessing based on what my incident was at the park, and this was after the incident, and I and cops are probably on edge right now. They're looked at in the microscope, and that's too bad, because that's not their role. They're here to protect us, and it's just too bad that I witnessed that particular incident on a young boy with just a water bottle in his hand. I mean, if he had anything that I felt in his hand that was a threat, then I totally agree with the number of officers that showed up.
Okay, fair enough. There were a list of several kind of broad statements, and you were asked to sort of rank your opinion of these statements from strongly agree to strongly disagree. Okay? So my question is about just a couple of those I want to follow up. You were asked the question, police in my community make me feel safe, and you check the box, I somewhat agree with that. Can you explain your thinking there?
That was just based off that incident that I'd seen in the park.
Okay. You were asked the question, police in this country treat whites and blacks equally, and you somewhat disagreed with that statement.
I think it's really based on the officer and their opinions and how they address people. I know without personal experience, but I've just heard that some officers aren't the best and they don't treat everybody equally, and I think they should. Doesn't matter who they are, they should treat everybody the same. Whether they pull them over for this, they pull them over for that. We shouldn't have, based on your racial and how you look, determine how you get treated when you get pulled over.
Okay, fair enough. You were asked your opinions on both Black Lives Matter and Blue Lives Matter, and I believe you sort of have the same response, at least generally. You write, I believe all lives matter, doesn't matter the color of their skin or nationality they are, all lives matter, underlined.
I truly believe that.
But yet your opinion of Black Lives Matters was somewhat unfavorable. Why would that be?
I'm not sure why I answered that, because I still strongly believe that all lives matter. Doesn't matter who they are, what they are, they all matter. We're all important.
Now, I know your employment takes you, or you work in a clinic setting.
Correct.
And I'm assuming with doctors and nurses, and you have relationships with doctors and nurses in a professional context.
Correct.
If you were a juror on this case, would you call up one of your doctor or nurse friends and say, this is what these doctors are saying?
Absolutely not.
Okay.
Michelle, we listened to this particular juror say they couldn't watch the whole video because one human's hurting another human, trepidation about seeing photos, somewhat negative opinion about what Chauvin did to George Floyd, and on and on. I would assume as a former lawyer, rather, and a jury consultant now, this would be one of those people that you don't want on the jury. Is that right? As a prosecutor?
This person would definitely, yes, as a defense lawyer, this person would definitely concern me. I mean, the defense lawyers are to some degree going to need jurors who are willing to dig in and truly review the evidence. And this juror is saying she's going to have issues with that. And it's really interesting because this juror, as she was talking about her role, she says, that is my role. She doesn't say, I can do that. Saying that's what a juror should do versus that's what I can do are two different things. And that really is a red flag to me.
Yeah, Doc, there was a civil settlement. We'll probably get into this a little bit later, but I found it very odd that it happened right now. And then there's a big press conference right in the middle of jury selection. How much does those kind of things affect the psyche of these people who are already nervous and indicating they're nervous about what their decision is going to be and how it will affect their safety?
Well, it certainly is going to affect them, Bob, to the extent that you're looking at clinical words like transference. Okay. So you already have the city saying, we messed up, here's several $1 million, and now come here and be an impartial juror and be fair to these police officers and be fair to the deceased. And one of the things I want to mention that's very important clinically is the idea of a potential juror looking at their own transference as far as trauma is concerned. Not only their own trauma and how that would play into them being a juror, but also any involvement they've had that has been traumatic with the police and how that would affect their perception as an impartial juror. So to answer your question specifically, as a forensic psychologist, if I'm a jury consultant, one of the things I'm looking for in any potential juror is what is their level of transference potentially going to be in looking at things like a lawsuit, as well as their own individual trauma and potentially even PTSD that may have happened in a previous situation that potentially could influence their role on this jury.
Yeah, excellent, excellent insights, guys. Let's go back to court real quick.
All right, Mr. Slisher.
Okay, well, there was a sidebar real quick there, so it'll be interesting to see what's going on with that. But we got to take a real quick break. We will be right back. All right, we are in jury selection in the case against Derek Chauvin for the death of George Floyd. Let's go back to court and listen to some more questioning of the juror by the prosecutor.
And I just want to go over again the conversation that you had with defense counsel about your views of Black Lives Matter. And you indicated that you had a somewhat unfavorable view of Black Lives Matter, and said you weren't really sure why you wrote that, the unfavorable view. Can you just, upon reflection?
I still really don't know where I was when I wrote that, but maybe I was thinking that sometimes, or maybe they were taking it too far. I don't know exactly why I answered that way. I'd have to probably try to remember where my mind was at that time, or did I witness something or see something, or I just can't fully answer as to why I would write that, because something must have happened or triggered me or that, because usually I don't, like I said, all lives matter to me. It doesn't matter who they are, what they are, they all matter because we're all important in this world.
And the question I had was, maybe do you associate that group with property damage or rioting?
No.
And do you believe that if someone was to make the statement that Black Lives Matter or some other lives matter, that they're saying other lives don't matter?
It can be perceived like that, okay. And I think they are just making it, maybe they felt, and I don't know because I'm not Black to know, maybe they felt that they were never heard. And that's why they are coming up with Black Lives Matter, because maybe they felt that they never were seen, they never were heard. And whereas I don't believe that to be true, but I'm not them, and I might see things in a different view.
And so when you say someone could perceive it like that it could mean that they're saying not all lives matter, do you perceive it that way? When you hear that someone say Black Lives Matter, do you perceive that they're saying that not all lives matter?
It can be perceived. Whether I perceive it like that, that's a great question. I would probably just tell them that all lives matter again. Mm-hmm. So maybe I do perceive that they think only Black lives matter.
And then so the next question or series of questions had to do with Blue Lives Matter. And so when you hear someone say Blue Lives Matter, do you perceive that in the same way, that maybe they're saying not all lives matter, only blue lives matter?
I took that to perceive everybody else. Blue lives, well, maybe I'm misinformed. I don't know what Blue Lives Matter mean, but I took that to mean that that's everybody else.
So I should follow up. I mean, what is your understanding of what that means if somebody were to say Blue Lives Matter? What?
And have them clarify, what do they mean by blue? Okay. What does blue mean?
Okay. What did you think it meant when you answered the survey?
That meant everybody else.
Everybody else. Did you associate, or have you ever associated that Blue Lives Matter with police officers?
Oh, so that's what that means. Is blue means officers. Say that question again now, please.
Sure. And I think you answered it. But at the time you were filling out the survey, did you have an understanding that Blue Lives Matter actually refers to police officers? Blue lives.
I can honestly say no, I didn't perceive it like that because I didn't know what blue meant.
Okay. On the survey, you indicated that you believe that sometimes local police departments will cover up instances of excessive force rather than to correct it. You said you somewhat agreed with that proposition. Do you recall that?
That's probably based on my witness in the park, because when we were walking down the path and the officer told us to stay back, and I'm like, well, I'm kind of concerned for this one kid. There's like 5 officers, and he said, stay back. And I'm like, okay. So, I mean, that was I've never had any incidents or witnessed anything other than that one incident at all with any police officers at all.
It sounds like that made an impact on you, though. You remember how long ago that was?
It was last summer, August, September. It was a really nice day. We were out walking. We were just out for a long time. We were out for a long walk, and that was just, something happened right in front of me, which I've never been witness to, and that's probably why it's stuck with me, because it's my only incidents that I've seen.
When the officer, so you indicated that you saw something that concerned you, but the officer told you to stay back and repeated it?
Correct.
How did it make you feel when the officer said that to you?
Kind of like I didn't matter, that I was concerned with the particular boy that was being harassed, is how I looked at it. That I should stay out of mind your own business type of thing.
And you said that the officer said this twice. Did you attempt to argue with him or ask a question?
No, I'm not in any position to argue with an officer. I just stayed back.
Okay. Do you know why he said it twice, or?
To probably make his point across.
Okay.
I don't know.
It wasn't in response to you asking a question or attempting to insert yourself?
I just was, like I said, I was walking up to him and he said, stay back. And I said, well, I just concerned for that kid. And he said, stay back.
Okay.
And so I did.
Okay. Sometimes when I ask a question, people tell me I'm arguing, so I just need to clarify. Not you.
No.
All right. Do you have any concerns?
All right, doctor, we got to toss this one to you. What is going on psychologically in your mind? This juror seems to give good answers on either side, but they're very strong opinions that could, depending on which way she's more, her predilection goes towards, could really be devastating to one side or the other. It's a mixed bag. But she also said right at the end, not her position to argue with police officers. And then all that confusion about Black Lives Matter, and she didn't know what Blue Lives Matter meant. She thought it was everybody else, and that Black Lives Matter took it too far. What are your thoughts? A mixed bag, no?
Absolutely a mixed bag, Bob. And I think for this juror who's coming across really as extremely naive, it's something that we really have to look at, because I think the prosecutor's doing a good job of at least bringing to the front this individual juror's perception of law enforcement versus her personal experience with law enforcement. And that's going to be an important psychological concept for any potential juror in this case. So does this juror have the capacity, based on this mixed bag of responses, to really delve into whether or not there was reasonable force used by Officer Chauvin? Or are they just going to be clouded not only by the chronology events, the social mores of blue lives, Black lives, all lives, getting caught up and lost in all of that diatribe, or are they going to, is she going to be able to really focus in on what actually happened? And it sounds for this particular juror, like as they say in England, it's all gone horribly pear-shaped already.
Okay, Michelle, she also indicated that she somewhat agrees that police cover matters up, and she had that negative encounter with the police officer who told her to stand back during an incident she was involved in within this past year, and you could tell it left a bad taste in her mouth. As a jury consultant, what are you telling, if you were on the defense side, what are you telling them with regard to these responses? And if they have to, are you going to ask them to utilize one of those precious peremptory challenges?
You know, this is a real split one, because if I'm looking at this as a defense lawyer, this is a potential juror who has had some really negative experiences that she's at least witnessed fairly recently with law enforcement in this community. On the flip side, she has made several statements that, to me, and I'm curious our psychologist's view on this, seem like a very us versus them mentality with the Black Lives Matter movement. And I really also questioned her naivete as far as the Blue Lives Matter. And I would be digging into this potential juror's social media to cross-check that and make sure, because I don't know how you've never heard of Blue Lives Matter if you're on any form of social media, whether you agree with it or not. And so, this is really a split juror. At the same time, she has made these statements of, I think that it's Black Lives Matter and Blue Lives Matter must mean everyone else. And she makes statements about it coming to her neighborhood and them coming to her neighborhood. And those statements concern me if I'm on the state side as well.
Really interesting observations. Thank you, guys. We're going to take a quick break, and we'll be back with two of these great guests with their unique perspectives on this jury selection on the other end of the break. Okay, we have juror number 9. So that juror that we were just discussing got through the gauntlet, if you will. So that's 9. We're looking for 14. So we're moving. Let's take a real quick at the weekend review from our very own Anjanette Levy with regard to the jury selection that occurred last week.
When you first received your jury notice, what was your initial reaction?
I was super excited.
Excited?
Yeah.
There were some lighthearted moments during the first week of jury selection in the trial of Derek Chauvin.
Go ahead and throw me under the bus with your fiance.
Okay, I will do that.
But for the most part, the questions were very serious about jurors' ability to be impartial and make a decision about the death of George Floyd and Derek Chauvin's culpability based solely on the evidence presented in the courtroom.
We need police reform.
I mean, are you open to the possibility that police reform is not needed?
No.
The defense used a strike to eliminate that juror. Derek Chauvin and George Floyd have become names known around the world after a cell phone video of Floyd's arrest went viral. But that won't be the only evidence the jury hears and sees. Attorneys are also mining social media accounts of potential jurors.
You posted and you have an opinion that 38th in Chicago is sacred ground or holy ground. I don't remember what you used, right?
The defense questioned the juror about whether he could actually be impartial.
Would you be able to proudly say to your friends and Facebook followers and family members, I was a juror who found Mr. Chauvin not guilty?
Objection.
I guess I can imagine that possibility. That's probably as best I can answer that.
Wow, really, really fascinating. Doc, I want to go to you real quick. I've expressed these concerns before. I don't care if people have formulated an opinion on one side or the other of this case. What disturbing to me is you got an incredible amount of media presence and pressure. You've got people demonstrating and protesting. You have jurors saying that they're concerned for their safety. And so far, the police side of this has not shown up to any things. You got a city settling, which I find to be extremely reckless a case and allowing a press conference to occur with respect to it right in the middle of jury selection. I mean, we should be seeking a fair trial, but at a certain point in time, look, whatever your point of view is, that's what we want, a fair trial for any defendant. And I say that as a former prosecutor. I just think it gets to a point where I don't know whether these jurors will succumb during the course of the trial to all of this. And what can the judge do to stop it?
Absolutely. And you look up the word impartial, and what you'll see is treating all disputants fairly and equally. Okay, Bob? So we're really asking them to have selective amnesia across the board and say, forget about everything that you've heard. Forget that there's been a lawsuit. The city has paid these millions of dollars, essentially admitting culpability for what happened to Mr. Floyd. And then saying, well, hang on a second, come in now and be impartial and judge this officer fairly and equally, and therefore impartially. And that's a mammoth task, especially when we're weaving in these other things that you've already mentioned, Bob, which include the individual's personal experience, their perception of law enforcement, their observations of law enforcement in the community, and their own race in terms of their perception of how they've been treated individually at different times by police officers. How do they take this massive weight of information, as well as the chronological events that have led him to where we are now, and be fair and impartial? It really is going to take a special juror who's going to have to maintain her or his objectivity all the way through.
Yeah. Michelle, as a jury consultant, but moreover, as your experience as a trial attorney, even when you're prosecuting cases or you're defending cases, you want it to be about the evidence that comes out into the courtroom. And I mean, obviously this case is huge, but a $27 million settlement goes on. Then there's a settlement conference with no gag order in place, right at smack dab in the middle of jury selection. Call me conspiratorial, but I don't believe that was just a coincidence.
Yeah, I mean, I don't know the reasons behind the timing, but I do find it really interesting. And if I'm the trial judge or the defense attorneys, I find it very concerning for getting a fair trial. And, when I did criminal defense, I defended many people of color, and I was on the flip side of this because, that's the reality of what we see in our system and some of the unfairness. And when I was on that flip side, I wanted a fair trial for my clients. I wanted the people who were sitting on the jury to be able to set aside whatever they had in their life and to listen to the evidence and make their decision based on the evidence. But when you have all of this noise that is just massive in this case, and you have a $27 million settlement, and in addition to those millions of dollars, you also have reforms announced. And I think about $500,000 was dedicated or is being donated to the business district where George Floyd's death occurred. I mean, these are things that are not just a monetary settlement to get this resolved, but are admissions of wrong acts. And go ahead.
No, I was going to say, the thing that's disturbing about it is the settlement of a civil suit has nothing to do with what you have to decide in a criminal case. There's all sorts of reasons, Doc, why towns decide for cost effectiveness, publicity reasons. Let's just move this along and get it out of the way. But to Michelle's point, jurors are going to hear that, and it's like an admission that something was done wrong. My question to you, Doc, is can this guy possibly get a fair trial? Will a fair trial occur here? Can these jurors fairly decide this case with all this other noise and static from outside the courtroom?
Again, it'll come down to how effective each side is in terms of picking the right juror. Remember, when you have a history of PTSD in general, for example, and you're carrying a lot of trauma, and you're dealing with a death that was so violent and so uncalled for, and now being asked to be a juror on that trial or on that jury panel, that's incredibly hard because of your own personal stuff that you're bringing into the equation. And so it doesn't matter how effective each side is. It's really, in my clinical opinion, it's going to come down to
Doc,
who the individual is.
Okay, Doc, sorry to cut you off, but we got to take a hard break here, but we will be back on the other end. Stay with us. Okay, welcome back. Jury selection is going a little faster than we thought it was. We have 9 jurors. They are now in recess. So this gives us a great opportunity with our 2 great guests, a criminologist, a psychological forensic person, as well as an attorney who is a jury consultant. You can't get any better skill set than that as we're evaluating this case. But let's take a look to what we were just discussing before the break about this $27 million settlement that just popped out last week, causing all sorts of press conferences and all sorts of information that could potentially poison the jurors. Let's take a look.
Go ahead and read for the record that Councilmember Goodman moves to approve the settlement of all claims asserted in Kara Nelson Schaefer, plaintiff as trustee for the next of kin of George P. Floyd Jr., instituted legal proceedings against the city of Minneapolis et al. In the United States District Court, civil number 201577, by payment of $27 million to the estate of the next of kin for George P. Floyd Jr. via persons and or entities as determined by the court's anticipated distribution order from the fund listed, of which $500,000 will be used for the benefit of the community around 38th and Chicago and Minneapolis, and to authorize the city attorney's office to execute any documents necessary to effectuate the settlement and dismissal.
I must again really acknowledge Mayor Jacob Fry, Council President Lisa Bender, Councilman Jeremiah Ellison, and my dear friend Council Vice President Andrea Jenkins for their extraordinary leadership to bring justice and change out of this terrible tragedy. For the city's leaders and their lawyers, especially their city attorney Jim Router, the Floyd family, and our legal team to reach this historic settlement, it says to America that we can do more than just point fingers, accuse one another, and engage in more division. We can actually come together and make things better. We can reach an agreement about what form justice might take, not wait for it to be determined only by a historical discriminatory criminal justice system. But responsible leadership says we do what we can to try to determine how we make a better world for all of our children. After the eyes of the world rested on Minneapolis in its darkest hour, now the city can be a beacon of hope and light and change for cities across America and across the globe. This would not have been possible, would not have happened without the extraordinary, progressive, and deeply moral leadership of this city council and its mayor. And for that, we do applaud you publicly as we have applauded you privately.
Michelle, I'm just awestruck by this on so many levels. Look, what happened to George Floyd was an absolutely horrible and atrocious thing, granted. But I used to do civil rights work, 42 U.S.C. 1983. This is the largest police settlement case, $27 million, that has ever occurred in the history of the United States. Breonna Taylor, who I believe settled for around $12 million, a completely innocent person who was shot by police officers. This is the randomness and how these judgments and settlements are being done. And what's really disturbing to me, and I as a lawyer would never have said this in my mind if it were in fact true, is that he's friends with all these people that made this decision. That's something that we used to refer to in the law as a conflict of interest.
Yeah, I mean, I think he's saying friends. I will say, from having been involved in some of these public cases myself, that sometimes as you're working on these cases, you become friends with people on the other side. So maybe that's what he meant. I'm not sure. I can't speak to Ben Crump's relationships with the city council members. But what I can comment on, and what I think is so interesting, is the timing of this settlement. And I don't want to be critical of these civil rights lawyers because they got an incredible result for their client for something that I do believe personally is justice. But the timing of it is very interesting. And when we are fighting to have a more fair criminal justice system, while this isn't the type of defendant that we're necessarily fighting for it for, we have to want that for every defendant if that's really what we want. And I have concerns about the impact of this settlement on a fair trial.
Yeah, well, Doc, to Michelle's point, I don't disagree with it. Just because Chauvin is a police officer and he is now a defendant in the case doesn't entitle him to any less legal and constitutional protections than if it was an African-American or a person of color that's sitting in that defendant's seat. And I'm pretty confident if there were one under those circumstances, in the typical trials that we deal with all the time, whether it be an armed robbery or shooting or a drug case, and this kind of pretrial publicity was occurring, and statements being made outside of court, what we call extrajudicial statements, people would be screaming bloody murder, that it's not fair to the defendant when it's occurring right in the middle of a complex jury selection. What's good for the goose is good for the gander. We can't throw the baby out with the bathwater here and allow this to be the way we go forward with all cases, not just this important case, but all other cases that are going on all over the country right now as we speak.
Right. So is it a cliche, innocent until proven guilty? Or are we really going to have the opportunity for this officer to receive a fair trial? And remember, we're compounding all of the things that have happened chronologically, Bob. And now we're asking the jury to look into specific law enforcement issues pertaining to use of force, excessive use of force, what a reasonable officer would do. And also, and perhaps most importantly, remember, we have two different autopsies in this case. We have the independent autopsy and we have the one that's done by the county. So now we're asking jurors to say, okay, put all of this aside and let's focus on mechanical asphyxia versus traumatic asphyxia and really concentrate on the minutia. And remember, the longer this goes on from a psychological perspective for these jurors, Bob, the more difficult it's going to be to sustain their attention. And when we get into the weeds on some of these matters, they're really going to have to stay positive, stay alert, and stay engaged in order to give Officer Chauvin a fair trial. That's for sure.
Well, I'll tell you something else. And again, people look at these things from a political lens as opposed to a legal one. Damages are supposed to be awarded for pain and suffering that the individual went through. And again, this was a horrible thing that happened to Mr. Chauvin, as well as lost earnings in the future and things of that nature. They came up with a number, $27 million for that. And I've never seen anything like it. And in fact, they're even telling you they've never seen anything like it. Anyway, so let's go to the Ben Crump now discussing the Floyd Justice and Policing Act.
How have you all worked with the caretakers of George Floyd Square who have released a list of demands to...
And I will say this, I know the family has said that they're going to give back, and that was the family's decision that they want to be part of the solution. And I think that's what the city leadership is saying. They want to be a part of the solution. Now, we don't have all the answers, but we believe together we can solve all the problems.
Michelle, listen, this is the thing another thing. Nobody ever has the answers. The money gets paid, and then no one has the answers, and they move on to the next case. This is the problem with trying to reform police work, which I did. I substantially informed internal affairs when I was the county prosecutor, but every place was doing it differently. It would be nice to know that somebody has the answers. What do you think?
You know, I always tell my clients who come to me, sometimes I handle some civil rights cases myself, is that what is the point? What is behind it? What does this do? And I really do believe that for companies, for governments, for institutions, money talks. We can't put the entire city in prison. You know, I hope that we will see justice in the criminal process, but how we motivate cities to not have officers like Chauvin out there is through civil penalties and civil, facing that civil liability and that risk. And to me, that is part of what this settlement speaks to. I know when Chris Stewart spoke, he was one of the attorneys for the family. He said, 27 reasons for justice and 27 reasons for change. And I know that that's a lot of money, but this has been a long time coming, and it speaks volumes, not just about the horrificness that happened to George Floyd, but about the change and the liability that I think that the city faced, and they realized that, and that's part of what this settlement is.
Yeah, Doc, look, it's an astronomical amount of money. And right now in federal and state courts across the United States of America, there are people that have been killed by the police, some in a much more horrific fashion, unfortunately, and there is need for police reform. And what happened to Mr. Floyd was absolutely unacceptable, but they're not going to get anywhere near a $27 million settlement. They'd be lucky. I've had cases where they won't even settle the case. They'll go to trial and let the jury call it. Why was it that this was the case where that kind of historic, and it's true, highest award in a settlement was ever given in a police fatality case?
So then the question becomes, from a clinical perspective, what is Minnesota saying by offering 27 million reasons why they were wrong? What are we saying? Are we saying that there's a monetary amount now that we're putting towards justifying the wrongdoing from a civil perspective, and therefore the city should be perceived in a certain way? Because remember, this reflects on the city of Minnesota. It reflects on its police department, and the police department is an umbrella. It's underneath the umbrella of the city. So if you're a potential juror, getting back to the fair trial issue, Bob, you're seeing the police department underneath this umbrella of responsibility, and you're saying, okay, if the city of Minnesota is saying there's 27 million reasons why we're wrong, oh, please give this man a fair trial now. What are we saying for the officer who's now trying to get a fair trial? Are we providing some semblance of a fair playing ground or a fair playing field, or are we, setting the juror into a situation where they're mired by this myriad of noise that's just perforating around them, and then asking them to judge impartially?
Yeah, right. Yeah, like it can really, that's really the effort. They want to achieve the goal, what they think is a fair goal. But I'll tell you this, I'd love to be a fly on the wall the next time there's a police fatality case and a death case, because if I'm the lawyer representing that next victim, and unfortunately, it's going to happen, I have 27 million reasons why I want the same thing that George Floyd got. We got to take a break. We'll be right back. We have 9 jurors, and the court is in recess now, so it gives us an opportunity to talk to our great guests. One of the motions that was made in court was whether a psychiatrist could disclose information about prior patients. Let's take a listen to it, and we could have no better crew than the crew we got here, especially with the doctor who's a forensic psychologist.
If, for example, a pulmonologist is talking about the science and the medicine of how it is a person dies of asphyxia, what are the stages? And they identify 3 or 4. That first you see this, then second this, and then third, and then finally the end stage.
Right.
And then the pulmonologist says, clinically, I have experienced and seen this in many patients. Each of the 4 steps or stages.
That makes sense.
It doesn't mean I'm talking about it in the context of Mr. Abernathy, but it does say that I've got clinical experience where I've actually experienced this in the field, and that's a part of my knowledge base. That I can share with the jury.
And that seems appropriate.
And so that's, Your Honor, where we're at then. And in that instance, we're on the same page. We don't intend to bring this up as an individual case study, as in talking about an individual patient. But the clinical examples will simply be that. They will be clinical examples of known medical causation mechanisms. And here's how we see it in the actual field, going from the textbook and the science and the abstract to reality. And the clinician should be able to talk about that clinical experience.
And I agree. I think the only exception is, I had a patient once. I think that's problematic because it does not show the general experience that they've had. It could have been a rare, idiosyncratic response to some type of situation. That's the problem with anecdotal evidence. You don't know if it's just, something that was rare and this person had a reaction that And so that's the problem, I think, with those single, I had a patient ones. But I think everything else you're talking about, I've had patients with this thing talking about the commonalities and what they see. And that forms the basis of their opinion. I think that's absolutely proper. So I think that basically, and what I'm going to rule is, you can't get into recounting individual patient anecdotes because you don't know if it was a rare or odd response to a certain medical condition. But generally talking about their experience and treating patients with this, and this is what he's found, that makes sense. So no, I had a patient once evidence. Everything else I think is pretty much in bounds.
All right, Doc, do you want to break that down for us, and based on your experience, what's occurring here, what the judge ruled?
Absolutely. So what the judge is saying, that the anecdotal narrative of saying I had a patient once is a no-no. It's okay to generalize to the extent of, in my clinical practice, I've experienced different things or had specific clinical experiences. So the judge is saying, and really I think trying to focus the psychiatrist who's potentially going to testify after having evaluated Officer Chauvin, to really focus in on their report and say, this is what my report says based on my specific evaluation of this police officer. I have had other experiences, generally speaking, where XYZ might have happened. But one of the things you don't want to do as a forensic expert is stray too far away from your own report, your own evaluation, and start telling a narrative, because you'll probably end up getting objected to by either side, and you end up losing your credibility on the stand. So I think the judge is really setting the table, Bob, for any potential expert, specifically a psychiatrist in this regard, to stick to their own specific evaluation. And I think that's a good thing in relation to providing an absolute clinical opinion versus an anecdotal narrative.
Excellent, excellent. Michelle, what are your thoughts, and how does this kind of testimony affect the jury?
I really think that, what they're talking about as far as the motion is fine as long as it stays generalized. But I do think if an expert were to get more into specifics with a specific patient, I would think not only is that problematic from a legal perspective, but it also might be more persuasive if it's allowed in to a juror. And I really do think that would not only be problematic from the end of the doctor and HIPAA and privacy concerns, but also just in the proper admission of evidence and the potential persuasiveness of that kind of individualized patient information that we don't want to factor in as a narrative that is outside the evidence in a case.
Right. And we also have another clip of something that went on with a juror last week who was scarred by watching the video. And we even heard some of that today. It's obviously a very disturbing video, very impactful, and a terrible situation that occurred to Mr. Floyd. Let's take a listen.
Sometimes jurors come in and they think that if they give a certain answer, if they say, I can't be fair and impartial in this case, that's somehow a failure. It's not. If that's what it is, every case is different. It involves different issues, and we all bring our differing backgrounds here. And I'm not questioning your answers. I'm just saying I want to give you the space to say, because you're not failing. If you are giving honest answers, that's all we require. There's no failure in saying fair and impartial. And if that's what you want to say, I absolutely accept it. Don't get me wrong. I just want to give you the space to be able to say one way or the other. Do you think that I'm going to focus on one issue, and that's the presumption of innocence? The defendant is presumed, as I told you yesterday, the defendant is presumed innocent of the charges made. And the fact that he's on trial cannot be held against him, or the fact that he's been charged. Do you think you could do that, is presume that he is innocent as you enter the courtroom?
I wouldn't like that verdict, but...
Okay, so if it was not guilty, but right now you're supposed to, as opposed to at the end of the case, right now you're supposed to presume he is innocent. And you said something about you can't unsee that video. Perfectly legitimate observation. Do you think with that it would be hard for you to presume the defendant innocent during the trial?
I do.
A viral video, Doc, and extremely disturbing to watch for sure. What's the play here if you were representing the defense? There are some that say that the defense should play that video over and over and over again to desensitize the jury to it. Is that a smart move? And if not, how do you get it? Because look, it's about as bad as any video you get in terms of what Mr. Floyd went through.
I would say it's a horrible move. I'm not sure what Michelle would say in terms of a legal strategy, but as far as a clinical strategy, if you're trying to get an objective juror on the defense side, one of the key symptoms of PTSD, Bob, is re-experiencing. And so if you're re-experiencing this video over and over and over again, you're being not desensitized, but you're being essentially exposed. You're witnessing and experiencing the beating of this man, the strangulation of this man over and over and over again. And so to say that it's being used as a strategic measure by the defense in order to advance their cause, I think is preposterous, and it can only help the prosecution in their case, at least from a clinical perspective, as a potential juror and looking at his or her psyche.
Yeah. Michelle, a person who has yourself tried some very high profile cases up to and including capital murder cases, and now as a jury consultant, it's been my opinion that prosecutors would be smart to keep it simple. The video speaks for itself, their most powerful and persuasive piece of evidence, but also the fact that another police officer involved in this who was charged had made a suggestion to Chauvin that he put him in a side position, recovery position, and Chauvin refused to do it. As well as other, of course, the people that were witnessing this saying, you know, you're killing the guy, as well as another person that came to render aid who was a paraprofessional that Chauvin pushed away. And then sum it up in this way. He's got his hand in his pocket as he's leaning on this guy's neck in violation of the policies and procedures that say once the person is no longer resisting, you have to put them in a recovery position and close the case. Is that what do you say to your client? If you're a jury consultant, look, you got to go for lesser charges. There's no way you're getting out of all that.
You know, it's a tough one. I think this video is something that if I'm the state, I am breaking down, just like you described, all of the points where Chauvin had the opportunity to let this man live and he chose to kill him. And I am highlighting that. And if I'm the defense, I do not want to show this video. I want to avoid this video to the extent I can and try to refocus on other things. Some of those things may or may not be admissible in the trial, but this video is not good for Chauvin. It is not good if you're the defendant. It is something that I view as very damning, and I don't see how any amount of showing it would desensitize a jury into thinking that it's not.
Yeah, I just can't see how they're going to get around the whole thing. It's got to be from the defensive side that we're going to try to get something lower because that video is atrocious. And here's the man crying out, I can't breathe, and calling for his mother multiple times. It doesn't get much worse than that. We got to take a quick break. We'll be right back. Welcome back. We have our very own Kim Johnson, who is at the scene. Kim, there's a lot going on here. Any updates?
Yeah, Bob, just a couple of moments ago, we have a small group of protesters that have gathered here on 4th Avenue, right outside the courthouse where the Derek Chauvin murder trial is taking place. These protesters have blocked traffic on both ends here of the block. They're holding Black Lives Matter signs and Justice for George Floyd signs as well. This is jury selection underway today, and we've made progress. We're past the halfway mark when it comes to seating a jury. Today, attorneys have agreed to 2 additional jurors. The first one picked today is a black man in his 30s. He works in the banking industry, says he likes sports and music. When questioned by the defense, he said he didn't think that Derek Chauvin set out to murder anyone that day. He also wonders, though, why the other 3 officers didn't step in. Take a listen to what he believes about Black Lives Matter.
You were asked a couple of questions about both the Black Lives Matter movement and the Blue Lives Matter movement. You indicated that you have a very favorable impression of the Black Lives Matter movement, and you wrote, Black lives just want to be treated as equals and not killed or treated in an aggressive manner simply because they're black. Can you just explain that a little bit more?
explain my answer?
Yes.
Could you repeat what you explain?
Sure. What you wrote is, Black lives just want to be treated as equals and not killed or treated in an aggressive manner simply because they are Black.
Okay.
Right? So, I mean, I guess I'm asking is, I understand that your perception of the Black Lives Matter organization is favorable, but
well, could I pause you? I don't know Black Lives Matter as an organization.
Okay.
I don't know it as an organization. So maybe that's. I mean, I don't know if that's how the question said. I don't know if it said Black Lives Matter organization. I don't view it as that. So I don't. Okay. That's not how I subscribe to that.
So I think it's been in previous jurors, it's been sort of somewhat described as a movement on one hand and organization.
I don't think of it as either. I just think of it as a statement.
Okay, fair enough. And with respect to the Blue Lives Matter, you had a neutral opinion and you wrote, although I do believe officers' lives matter, I feel like the concept of Blue Lives Matter only became a thing to combat Black Lives Matter, whereas it shouldn't be a competition. Stand by that proposition?
Yes, because like I said, Black Lives Matter is just a statement. It's not a thing. It's just people of Black, pigment, their lives matter. It's just a statement.
And the second juror selected today is a white single mom who works in healthcare. She rides motorcycles, sells Pampered Chef. When asked about Black Lives Matter in her questionnaire, she wrote that she believes all lives matter. She says that she's seen the video of George Floyd's death, but hasn't been able to watch the entire thing because of it being, quote, too disturbing for her. So let's recap where the jury sits right now. So far, 5 are white, 2 jurors are Black, 1 Hispanic, and 1 describes herself as multiracial. And of the jurors, 6 of them are male and 3 of them are female. Bob?
Are we seeing anything with respect to Blue Lives Matter protests or any counter arguments, or is it just these folks out here? And do you have any information as to why the police, who typically respond to these things in most cases, aren't?
Yeah, that's a very interesting point, Bob. So this is a movement here. The group organized is a local Minnesota immigrant rights advocacy group, and they've been out here for maybe 30 minutes, been very peaceful. But, these are the first protesters that we've seen in a week. The only other time we've seen any demonstrations was on the very first day a week ago today. Otherwise, it was very, very quiet and uneventful out here around the courthouse. And the entire week, we have seen 0 supporters of the Blue Lives Matter group that you have, that you just mentioned there. And it is interesting. There are no police that have come to tell them that they can't block traffic. It is against the law to block traffic. But over the past 9 to 10 months since George Floyd's death, that's kind of been the case. Police have remained a little bit more standoffish, as you can imagine. They haven't been pressing, and if the protests are peaceful, they haven't really come up and stopped them. So perhaps that's kind of what's going on right now, too. This is also a quieter street, so it's not really causing too much of a disturbance. Perhaps if it was a busier street, we would see police presence here.
All right, Kim Johnson, thank you very so much for your reporting. Stay warm. I can see you got snow flurries in the background there. Thank you very much, Kim.
Oh, yeah, it's snowy Minnesota.
Snowy Minnesota. Okay, be well. Let's go into the jury demographics here and the judge speaking about that with regard to the whole panel of jurors that have been called up on this case. Let's take a listen.
Your Honor, I was going to say, from the state's perspective, I think some transparency in this process is a good thing. And so we're not going to object to either self-identification or just simply the release of how they self-identified in the survey if seated.
I think it is an appropriate, Blood, your question, if there was a group to ask that question specifically. I think the concern by St. Paul may be that I'm releasing something out of a jury record. So we're just going to consult with them, and I think getting the information out appropriately, following all the appropriate rules in that would be important, but just if anybody had any views about the whole idea. so we aren't leaving people guessing, but being transparent about what's going on here.
Michelle, it's interesting. The release of jury demographic information, I think, is very important for the lawyers to make an assessment of their case. That's number one, and so that's on that side. The second thing that I also find interesting is that they released the jurors' identities after the trial, which a number of jurors have brought up, gives them some pause for concern in this case. What's been your experience with regard to these two kind of issues, the demographics and then releasing the identity of the jurors?
Yeah, my experience has been that the basic demographic, male, female, race, age, those sorts of demographics are often heard in open court and that's released, but their actual identities are often protected and not released until sometime after the trial. But if you backtrack and look at some of the really high profile trials we have seen over the years, the Trayvon Martin trial, the Casey Anthony trial, some of the others that have just been big and very publicized, they have often had a little bit of a waiting period before they release the identities of the jurors. But that is a very state by state, I think sometimes judge by judge decision. And, it's something I know a lot of the people on this panel have expressed that they're concerned about, and I could understand why.
Yeah, doctor, especially, and again, I go back to let's have a fair trial. That's what is entitled to happen. And what happened to George Floyd, again, was a terrible, horrible thing. But if there's going to be a conviction, let's get it the right way. How do jurors get this fear factor? You cannot tell me it will not be there when they're deliberating about what the repercussions of their verdict are going to be. And how much do protests and things like that are occurring outside the courthouse without any opposition protest push them towards more, or push them more against Chauvin because they're seeing more, outward concern and agitation about what happened, understandably, to Mr. Floyd?
I think it would depend on the individual juror's level of anxiety, Bob, in general. So if they're easily susceptible to being influenced by outside protests versus the facts of the case, then they probably shouldn't have been on the jury in the first place. However, we're all human. And we all come into situations thinking that we can be objective. And in this case, hopefully each specific juror can go in and keep an open mind, listen to the facts, listen to the evidence, and come to a verdict that they can live with and sleep at night with. However, if they're prone to anxiety and if they're prone to feeling like they themselves potentially could be in danger or fearful for their own public safety, then that could potentially subconsciously come into play in terms of their deliberation. So again, that's why this process we're in right now is so important, because there's no clinical wand to really gauge a potential juror's anxiety, Bob, but it certainly will come into play, not only in terms of their ability to listen to the evidence, but also essentially ignore all of that other noise that's going on in the background and maintain their equilibrium as it comes to moving forward and coming to a just verdict so that this officer can get a fair trial.
Yeah, excellent points. Michelle, I want to get your take on this. There's only 14 jurors being picked. I believe the court wanted to pick 16, which is kind of typical. I've seen a little bit more. It's going to be a long trial. There's a lot of witnesses. And to the point that the doc is bringing up, I've been involved in trials, and I know you have too, where jurors have gotten so over emotional that they can't continue to fairly deliberate and say they want off the jury. We only have 2 alternates, and that was because of the COVID concerns and putting all those jurors in. Are you worried we're going to wind up in one of those scenarios with a case that's got so much pressure associated with it?
I mean, that's a concern. I've certainly tried cases with far less pressure and publicity than this, where we've had issues like that with people who approach the judge mid-trial and have a concern that is so overarching and distracting that they can't proceed. And so 2 alternates seems like that could be a little iffy if something went, wrong for a person, or with COVID as well. I think I would have rather have seen 16. But, I'm sure he had his reasons for that decision. But you are right. Things like that come up, and the more pressure, the more high profile, the more likelihood that can happen.
Hey, Doc, what about the other 3 defendants in the case? Now, their case has been severed. Some have debated whether that was a good idea or not. But do you think that, you heard one juror kind of allude to this a little bit, Do you think that the jurors would be more inclined, that tape would be more impactful to them with regard to Chauvin, but not necessarily as impactful to them with regard to the other officers who may not have really been witnessing exactly what he was doing, like the one of the officers that was doing crowd control?
Yeah, I think that, hopefully they'll be able to differentiate between the 8 minutes and 46 seconds that took place in terms of these officers' individual roles. However, certainly, from the perspective of seeing the police officers working together cohesively as a team, will this individual juror be able to decipher the difference between seeing them blanketed as police officers who were doing wrong and using excessive force, or will they be able to drill down, if you will, into the minutia of what each specific officer did and the role that they played in the death of George Floyd? And so that will be, we'll see in time how each individual juror is able to do that. We may never know, but it's certainly going to be an important factor in terms of this officer receiving a fair trial.
Well, I think we could probably all agree that the other officers are going to have a better chance at trial than Derek Chauvin, given the way that video looks and what he did and his previous conduct. So we're going to take a quick break here at the Law and Crime Network. Stay with us for more great legal analysis. Okay, we have 9 jurors and they are on recess. So let's look at an interview that our Anjanette Levy did with Mark Garagos on the aspects of what does he think the outcome of this trial will be.
We've seen police officers put on trial over the years. Some have been convicted while others have not. Defense attorney Mark Garagos says some jurors simply have a hard time wrapping their heads around the idea of sending a cop to prison.
What I witnessed at the scene was 100% LAPD policy.
1991 in Los Angeles, 4 LA police officers beat Rodney King during a traffic stop. Those officers were acquitted in state court. Does that case foreshadow what could happen in the George Floyd case? Defense attorney Mark Garagos, who gained notoriety representing Scott Peterson in the death of his wife Lacey, believes so.
We've seen this movie before. The officers in Rodney King were acquitted because basically the case was moved to a jurisdiction or change of venue that was helpful to them.
2 of the 4 officers in the King case were later convicted in federal court of violating King's civil rights.
Here you've got the same thing, at least arguably, starting to be set up. If you read what's been reported.
Several media outlets have reported a federal grand jury is investigating Floyd's death as a backstop. Even with Floyd's death captured on videotape, Garagos believes not guilty verdicts are possible.
Chauvin has got a tough case. I think it's going to be a very difficult prosecution to make the case against the other 3 officers, and especially 2 of the 3 who were rookies.
There have been other cases where the evidence appeared overwhelming only to end in an acquittal. In Cincinnati, campus police officer Ray Tenzing's 2 trials for the shooting death of Sam DuBose in 2015 ended in hung juries, and a judge later granted a motion for acquittal. A federal investigation is underway in that case. But a jury also found Chicago police officer Jason Van Dyke guilty of second-degree murder in the 2014 shooting death of Laquan McDonald. Van Dyke is serving prison time for that crime. Everything will be under a microscope in the Chauvin case, including the officer's training and restraint techniques, which medical experts say caused Floyd's death. Minneapolis police had been trained in a technique that includes placing a knee on a person's neck.
It wasn't just the knee of Derek Chauvin on George Floyd's neck for 8 minutes and 46 seconds that killed him. It was the knee of the entire Minneapolis Police Department that killed George Floyd, because they have a pattern and practice of deliberate indifference to arrestees, especially young Black men.
Meanwhile, Mark Garagos believes Derek Chauvin will take the stand to try to explain his actions.
They're going to be testifying, because cops almost inevitably in these cases testify because they're used to getting up on the stand. They're used to giving their point of view. Alan Dershowitz calls it test the lie, but I won't go that far. But I will tell you that the cops will get up there. They will invoke officer safety.
Derek Chauvin's lawyers are expected to argue at trial that fentanyl in George Floyd's system actually killed him and not the pressure being placed on his body while he was being restrained. For the Law and Crime Network, I'm Anjanette Levy.
Excellent rendition. Michelle, let me go to you first. I mean, there's a number of comments that Mark Geragos made, obviously a very accomplished attorney. And then we got another clip from Ben Crump. And Ben Crump basically enunciated the standard for a 42 U.S.C. 1983 civil case, a deliberate indifference, practice and pattern and policies of deliberate indifference that led to the death of George Floyd. And that very well may be true and probably is true. But does that kind of lend a defense in a criminal case that, hey, I was following my training, I was doing what I was being told to do? And to Geragos' second point, it's kind of like what we just talked about in the previous segment, that the other officers, it's going to be more difficult for the prosecutors, especially because of their short time on the force. And you know, that whole heavy chain of command, and they were trying to get Chauvin to do things, but he was a superior officer and told at least one of the officers, no, I'm not putting him in that recovery position.
Yeah, I mean, they may have a pattern in practice, and I think the defense is certainly going to use that and try to rely on that. But did they have a pattern in practice to do that to the point that they did, that Chauvin did, which was almost 9 minutes, and to the point and past the point where someone was not responding anymore? I don't think that was the pattern in practice. And I think that pattern in practice was wrong, but clearly they went past it.
Yeah, for sure. Once the person is no longer resisting, and that was for a significant period of time. Doc, I want to go to that psychological point with the other three defendants. Will the jurors look at that inexperience and that this is a superior officer, and maybe it may not be legal, but have that emotional reaction that, you know, hey, Chauvin, let's assume he gets convicted. If he does get convicted, he paid the price for what he did, but these other officers were in a difficult situation. And then number two, I'm curious, should the defendant take the stand here to explain their actions? That happened with Van Dyke in the McDonald case, and it was a disastrous examination. He convicted himself.
Yeah, absolutely. I think what'll be interesting is, you know, will the defense be able to delineate or essentially effectively argue a kind of a deer in headlights for these rookie officers? Will they be able to effectively persuade the jury that, hey, you know, these guys were new, they were following what they believe was protocol, they were overruled by superior officers, and essentially they were in this deer of headlights state of mind, and that they were also extremely anxious and perhaps even may have made an effort to tell their superior officer that, hey, should we really be doing this? I think the truth will be told in the evidence as it unfolds. I know Mark Geragos. He's one of my clients. I work and do several evaluations for his firm, and I think he raises a good point in relation to your second point, which is, you know, the extent to which law enforcement training lends itself to use of force in a reasonable manner is something that we still need to know. And I think the jurors will be able to determine whether or not what played out was really use of force, or was it really these individual officers making a judgment call and exercising poor judgment, bad decision making, and really bad execution in their excessive use of force. And in terms of testifying, I've testified on hundreds of cases, and I've seen police officers testify in hundreds of cases. And in my experience, they're going to defer to the badge. They're going to defer to the training that they've received and really rely on the department perhaps to bail them out. And I anticipate that's what's going to happen when Mr. Chauvin takes the stand and says, I was just doing as I was told. Now, was he doing what he was told for over 8 minutes? I think that's going to be the challenge for the defense.
Michelle, I got to say, as a prosecutor, I would love Chauvin to take the stand. I'd love any defendant to take the stand, because that allows me to go bit by bit through that video. And when he says, my training told me this and that, and I was up here with your hands in your pocket, you're sitting there nonchalant with the guy's screaming, he's crying, he can't breathe, he's calling out for his mother, and these people are trying to tell you there's a problem. The community saw it. The EMT that came across and said that they would help saw it. One of the officers even saw it, and you did nothing. That would be, in my opinion, the cross. We've got a short period of time, Michelle. What do you think? Is it a good idea?
Yeah, I don't think it's a good idea on Chauvin's part to testify, but if I were a prosecutor, I would definitely be glad if he does, because I would take him apart piece by piece, just like you said.
Okay.
But, you know, Police officers are professional witnesses. I'm sure he has testified a number of times, and he may think that that's what he should do, but that is a sure dangerous choice for him.
Yeah, first of all, that decision is never made until all the evidence has been produced. Then you talk to your client about it. I think it's very dangerous for the reasons I just brought out. We'll be right back. Of course, you know this is Law and Crime Network, so we are covering this trial, gavel to gavel, the trial of Derek Chauvin for the killing of George Floyd. They are on recess right now. They've got 9 of the 14 jurors, so they are making definite progress there. Let's listen to our very own Anjanette Levy as she talks about jury selection from last week, in case you missed our segment earlier.
When you first received your jury notice, what was your initial reaction?
I was super excited.
Excited?
Yeah.
There were some lighthearted moments during the first week of jury selection in the trial of Derek Chauvin.
Go ahead and throw me under the bus with your fiance.
Okay, I will do that.
But for the most part, the questions were very serious about jurors' ability to be impartial and make a decision about the death of George Floyd and Derek Chauvin's culpability based solely on the evidence presented in the courtroom.
We need police reform.
I mean, are you open to the possibility that police reform is not needed?
No.
The defense used a strike to eliminate that juror. Derek Chauvin and George Floyd have become names known around the world after a cell phone video of Floyd's arrest went viral. But that won't be the only evidence the jury hears and sees. Attorneys are also mining social media accounts of potential jurors.
You posted and you have an opinion that 38th in Chicago is sacred ground or holy ground. I don't remember what you used, right?
The defense questioned the juror about whether he could actually be impartial.
Would you be able to proudly say to your friends and Facebook followers and family members, I was a juror who found Mr. Chauvin not guilty?
Objection.
I guess I can imagine that possibility. That's probably as best I can answer that.
Doc, we talk a lot about the term jury nullification, and that is a process where it's not lawful, but a jury listens to the evidence, and even though they think that the evidence meets the definition of the crimes charged, they nullify or they find the person not guilty or guilty of a lesser offense. What do you think with respect to this particular case and as it relates to Chauvin in particular, that a jury pretty much has no place to go as far as nullification is concerned, just because of the graphic nature of the video? And secondly, and I think very importantly, despite the fact that people may not like what I'm about to say, it is something that goes into jurors' minds. What was this all over in the end analysis? A counterfeit bill. A person lost his life for a counterfeit bill. That will impact the jury in my mind, no matter what you tell them as far as the judge during the jury instructions.
Yeah, absolutely. A $20 bill at that. And so, Mr. Floyd's life and the $20 that came into play as a counterfeit bill will certainly, in my opinion, from a clinical perspective, weigh on a potential juror's mind. That is such a tragic loss of life. So to answer your question, briefly, what I would say is, remember the possible sentences in this trial, and I'm not an attorney, but we're looking at the difference between a second-degree manslaughter of a sentence not more than 10 years, all the way up to a second-degree murder conviction. And we're looking at, 40 years or more, or not more than 40 years. So, that's a wide range for this jury to have to determine. And so in that regard, they're going to have to do not only their due diligence, but really be engaged and involved in leaving that counterfeit bill aside and focusing on the evidence that's presented to them. And I mentioned anxiety before, and also the noise that's around them. And so those are the challenges that this jury is going to have to endure, quite frankly, in order to maintain their objectivity to give this officer a fair trial, in my opinion.
Michelle, as a jury consultant, what people ask us, we do this all the time. What profession are you looking for as a defense lawyer? Like, I know we can't generalize completely, but this is what jury consultants do. What do you want to look for in that kind of person that you think would be more favorable to your side based on what job or profession they're in?
I'll tell you what I tell my clients, which is this is more of a process of deselection than it is who we want. But if I'm really looking at people who are the least bad for me, I tended on the defense side to be really open to teachers because teachers often are exposed to people from all backgrounds. A lot of them have worked with children who have been in different situations. And so I liked teachers, but it is more of a process of deselection than choosing who we want.
Yeah, that's a really good point, Doc. What do you think about that? The deselection aspect of it. Like, what's the least worst? I think for the defense in this particular case, because they're just trying to find anyone that would be sympathetic to maybe even a downgraded charge. In my mind, I don't think they think they're getting out of this 100%.
Absolutely. I agree entirely with Michelle. And I think it's interesting in my experience, you want to weed out what you don't want, and hopefully you'll find what you do want. And what you do want in this case, as a prosecutor, is someone that's going to really be able to objectively listen to the evidence. And what you want as a defense attorney is hopefully someone that potentially could be swayed to a lesser charge. Now, remember that each individual brings their own mental health into the equation here and their own history of experience. And so therefore, it really is going to come down to the ability of each side to be persuasive and objective, specifically relating to the evidence, and also the defense's ability to humanize Officer Chauvin. Because when I'm asked to write a forensic report, one of the things the defense attorney is asking me first and foremost is, hey, listen, Doc, I need to try to humanize my client. Can you do that, given the nature of this charge? And I've written many evaluations where I'm trying to humanize a given police officer based on what a jury would see as criminal conduct, and try to explain who they are and humanize them as best as I can. And that's the challenge, I think, for the defense in this case.
Yeah, humanizing Derek Chauvin after that video is going to be very difficult. Not to mention, if he takes a stand, what other evidence he may open the door to with regard to his prior conduct is something they have to watch out for. But, social media is playing a huge role in this, and it is in every trial now. Let's listen to the defense attorney with one of the jurors with respect to that.
If you felt, after all of the evidence was presented in this case, that the state had failed to meet its burden of proof beyond a reasonable doubt, would you have any hesitation in finding Mr. Chauvin not guilty?
I don't think so.
Okay. Again, it needs to be unequivocal, excuse me. Could you?
Yeah, I can imagine that, yes.
Would you then post about that on social media?
I don't know. I've kind of decided that I'm refraining from any of that kind of posting right now. I'm posting music that I like and that kind of thing.
Right. But I mean, you posted and you have an opinion that 38th in Chicago is sacred ground or holy ground. I don't remember what you used. Right? Would you be able to proudly say to your friends and Facebook followers and family members, I was a juror who found Mr. Chauvin not guilty?
Objection.
I guess I can imagine that possibility. That's probably best I can answer that.
Okay, fair enough.
Doc, what did you think about that exchange? It's a great question that the defense is asking, getting to whether or not he would be proud or boast about it on social media. And there was some hesitancy there. What did you make during that exchange?
Yeah, I'd love to see his social media. I mean, you used the term earlier, mining, or drilling down. Let's get it out. Let's look at it. Let's see what he has on there. And let's also see from a psychological perspective how that might sway him one way or another as a jury. So I think it would be fascinating to have the opportunity to use your word, Bob, which is mining into his social media to determine whether he's putting up this front or whether he actually has more of an opinion one way or another.
You know, that brings to mind, Michelle, what happens if you could just tell us if you've ever experienced it or legally what occurs if later it is found out that some of these jurors were not telling the truth with respect to what their positions are, and that was found actually on their social media accounts?
It could be cause for a mistrial. I mean, if that person didn't reveal that information and then they end up on the jury and they end up making decisions and they outright lied. I know specifically in the Zimmerman trial that they had stealth jurors on the panel, meaning they didn't make it onto the jury, but they had people who really wanted to be on that jury who were saying things in jury selection and posting another. And that was used as a strike for cause in that trial. And so stealth jurors holding back the truth or holding back their real feelings and bias is certainly a concern and on appeal if there's a conviction.
Yeah, fascinating stuff. And certainly no prosecutor wants that to happen for sure. We're going to take a quick break and we'll be back with more law and crime in this fascinating case. Stay with us. Welcome back. In the case of State versus Derek Chauvin for the killing of George Floyd, the jury is currently on recess. We are in jury selection. We have 9 jurors selected. We were talking about a press conference from the settlement last week. Let's listen to the family attorney for the Floyds, Antonio Romanucci, as he discusses what went on.
George did not need warrior policing that day. What he needed was help. I can tell you now, from a factual basis, and this is so important, listen to some of the great things that the city of Minneapolis has done that are implemented right now to prevent what we saw in that videotape. Already, the city has modified its use of force policies so that any hands that ever wind up on a subject from a police officer must be reported. You think of that. Any hands on anyone now is considered force, and the police must know about it. Commanders must know about it. Minneapolis has tightened its requirement for body-worn cameras. It's creating new policies on de-escalation. So important. New policies on disengaging, also when required. And you cannot underestimate the importance of the social services programs that they've implemented to help people, to make sure that they don't die needless deaths. But as we say in the courtroom, partial justice is no justice. The George Floyd family wants whole justice. And so we demand more changes if true reform is true to happen. What's been done so far is tremendous, and we all applaud the city of Minneapolis, but we want more. And guess what? The city of Minneapolis has said yes. They want more too. And we're going to work together to make sure that that more does happen. We commit to that. What do we want to do? We want to be working to ensure that this arbitration process, these union contracts that have become an absolute python grip on the police departments, I don't want to break unions, but you got to give the power to where it belongs. You got to give the power of discipline to those police chiefs that when they know something bad happens, that they can take that action. And if we can pass that bill, which I understand needs state passage, that legislation, think of how great it would be to name that for George Floyd.
Yeah, Michelle, when I was prosecutor, we tried to put a lot of internal affairs things into place. And sometimes there's pushback from the law enforcement community because it's like, you know, daddy's looking over me and micromanaging me, so on and so forth. But when we would dialogue about it, like, look, this is for job survival. And we're looking to make sure that you are not only tracking civilian complaints, which usually don't get as much credibility as when police officers or superior officers file complaints. When you are making sure that people are going for retraining when there's a problem, when you have a red flag warning system, this is the kind of stuff I wanted to hear, where the officer's conduct is taken globally into consideration and not just in silos of incident by incident. There's a way to do all of that. These things can make profound differences even in the culture of a police agencies when you dialogue about it being for your protection and so that you can have a job without having to be on trial, God forbid, for a crime or lose it. So what do you think about these reforms that they're coming up with here?
Well, I know Tony Romanucci really well, work on some cases with them. And I know these non-monetary reforms were a part of this settlement that the entire trial team representing the family was super proud of, more proud than any of the dollar amount they could have gotten. But I really think that it speaks to giving, as Tony said, the power back to police chiefs who know their employees better than anyone and who need to have the ability to discipline or get rid of officers who are a problem or who are violating their policies and who they get repeated issues and complaints about. And that will hopefully in the future help prevent more of these from happening, because we know that Derek Chauvin was not someone with a totally squeaky clean history as far as disciplinary issues.
Yeah, I can't underestimate the importance of making sure that these things are being tracked and monitored. What we used to do, and I throw it out there in case anybody's interested that's trying to do this act, is that the county prosecutor's office or the district attorney's office had the same computer system, so they knew what internal affairs was doing with regard to each of the individual departments within their county to make sure that there was no funny stuff. So, there are ways to definitely do this. Doc, let's talk about this de-escalation tactics and any hands on a person is considered force. There's also a whipsaw effect that occur with this too, and it comes from leadership, and hopefully this will occur, where some cops may say, especially through the union and other places, you know what? I'm not going in. I'm not dealing with it. Let it just happen because I don't want to put my hands on the guy. Now I got to write a use of force report. You've been doing this for a long time, working with police departments. Can you see that coming about in your mind psychologically from the way they look at this?
Absolutely. Absolutely. I mean, you're talking about body-worn cameras. You're talking about an individual's officer's decisions, Bob, to engage or not to engage. And really, if you look at the National Institute of Justice use of force of continuum, what a lot of police departments are trying to do is move away from obviously lethal force to less lethal force, all the way to basic verbal and physical restraint. And so how do you do that and still protect the officer at the same time? And my point is this: you want to do that in cases where obviously less lethal force than lethal force doesn't need to be used. And that comes down to the officer's training. However, officers also need to be trained. And when you talk about police reform, how educated or informed or well-trained is that officer to respond to someone like George Floyd, who has a prior criminal history, who has had substance use issues, and are aware of that, to be able to de-escalate? And so I think that moving forward for Minnesota's police department is going to be their challenge. You can talk about police reform all you want, but until specific officers have the exact necessary and specific training to deal with mental health issues, then it's basically a lost cause, because you're just reverting to the level or the continuum of use of force versus understanding each specific case as it comes to you and the specific mental health challenges that may present themselves when you're trying to de-escalate.
Okay, yeah. Michelle, what do you think about that? And by the way, I'm curious about your opinion. Do you believe that there should be qualified immunity and immunities to police officers, or is that an archaic tool to protect them?
I think it's an archaic tool to protect them. I think we're in an age now, and we're already starting to see case law come down that is going to change that. And I think that some of that has come from the voices and the protests that we heard this summer, that we can't just let this keep happening. And that qualified immunity is one of the things that protects officers in the government when they do bad things. And there has to be accountability by the government as well. But to Doc's point, I think, he mentioned at the end social services. And I'm really curious, from a psychologist perspective, how bringing social services into this picture. In a perfect world, if we had called those resources out, what do you think would have changed this picture, Doc, had we had all of those social services and brought those immediately rather than what we saw the day that George Floyd was killed?
Michelle, love to know the answer to that. I'd love to know the answer to that. Unfortunately, my producers are telling me we need to move on just a little bit. Hopefully we can get to that question later, Michelle, because they want to talk about a juror that got struck from the jury based upon their giving their opinion about police officers. Let's take a listen.
I want to follow up on the question. You responded that you somewhat agree with the proposition that because law enforcement officers have such dangerous jobs, it's not right to second-guess decisions that they make while on duty. And as you know, this case involves decisions and choices that were made by law enforcement officers while they're on duty. And you somewhat disagree that they should be questioned about those decisions. And so I'd like to ask you just how you believe accountability and review should be handled. Would it be better handled in a civil or employment setting and not in criminal court?
I mean, I think it depends on the severity of the case you're talking about. If it's something to the extent of this, I think it should be looked at from a higher level like we're currently doing. If it's, something much smaller, if we're talking of like a traffic stop or something like that, I don't know that it requires this kind of attention and all of the event details that led up to it.
We would hope not for a routine traffic stop and unless something went horribly, horribly wrong.
Correct.
But in this case, as the court told you earlier, the charge is murder. And you would be asked, if you sat as a juror in this matter, to determine whether or not an officer in the line of duty, based on decisions they made, had committed a murder. And what I need to ask you, given your statement that you somewhat agree that law enforcement officers should not be second-guessed for decisions they make in the line of duty, how difficult would it be for you to return a guilty verdict on the charge of murder for the decision a law enforcement officer made in the line of duty?
I think it depends on all of the evidence and knowing all of the events that led up to it.
And knowing all the events that led up to what?
That would help make the right decision for that. I think anybody can see a 10-second clip of something and make their own judgment, but if they know the full story that led up to it, what caused it, how we got to that second clip, it may open it for more question.
And if the government then, if the state met its burden of proving beyond a reasonable doubt all of the facts that would be required to render a guilty verdict for the charge of murder, would it still be difficult for you, to return that verdict, given your views of law enforcement and the kind of discretion and deference they should be given for decisions they make in the line of duty?
I don't think so, no. If we're proving something beyond a reasonable doubt, absolutely not.
All right, Doc, we're going to do this a little differently than we normally do. So what is your opinion about the opinions these jurors are expressing about police officers? And Michelle, the question you wanted to ask previous to that clip was?
Oh, the question previously was about social services and how that would have made a difference in the situation. I'm curious.
So to answer your question, Bob, I think that jurors have a difficult task, because think about what happened in response to your question. The chief fired these officers. The chief said, you're all fired. You're all terminated. And now you're basically asking a juror to say, my employer, my boss in the chain of command has made a decision to terminate my employment. And now I have to go in and be an impartial juror to all of these officers.
and I have to judge them on their level of wrongfulness or their, in this case, level of criminality. You're not even saying, well, they're innocent until proven guilty, because again, there's a specific cloud of admission of wrongdoing by their boss and by their department. And so they're basically coming in shorthanded to begin with. Now, that's not to say they're not culpable for what they did, but is that a level playing field? And in response to, Michelle, your question, the extent to which social services may have been able to at least mitigate the damage here, I think, is paramount. Because what we see here in Los Angeles is that in calls where you have severe substance use with individuals with prior criminal histories or individuals that are suffering from a history of real psychotic illness, schizophrenia, schizoaffective, and other illnesses, you really have a team-based approach to really assess not only the level of imminent danger, but also the extent to which this individual may respond to psychiatric care and therefore avoid some type of physical response or altercation. Now, that's not always the case, because we see many cases where individuals are high on methamphetamine and other drugs where the stimulant causes them to act out violently. And obviously there's nothing that an officer can do but defend oneself. But in response to your question, I think having more of a team-based approach, which you can't always do, at least some sort of consultation. And we see that happening a lot by telephone and by communication in terms of understanding whether the individual is a danger to themselves or others. The dialogue, it's just dialogue. It's necessary, especially in cases where officers start taking the law quite literally into their own hands, or in this officer's case, into his own knees, and pressing down on Mr. Floyd's throat for 8 minutes and 46 seconds. And I hope that answers both of your questions.
Did a great job, Doc, getting double teamed here with questions. Guys are both doing a great job. We appreciate it. We got more of this excellent analysis by these two folks coming back on the other side of the break. Stay with us, please. All right, the court is still in recess. We have 9 jurors, so we're making progress to that magic number 14. And it's all about the jury, folks. Those are the ones that these lawyers are going to lay the case into, the prosecutor and the defense, into their hands eventually, and ask them to make a decision in this such critical case of great magnitude in this country. Let's listen to Brian Buckmeyer from the Law and Crime Network as he interviews jury consultant Alan Turkheimer.
You bring in people that represent what the jury looks like. You match the demographics. You say, okay, Hennepin County's 80% white. And then you want to get a range of age, occupations, and get them in there.
Alan Turkheimer is the founder of the litigation consulting firm Trial Methods. He says jury selection is one of the most important phases of any trial, but will be key for both the prosecution and defense of Derek Chauvin.
From the defense perspective, in a case like this, you really want to have people who can get past the emotional aspect of the video, who are thinkers from a logic standpoint, who connect dots, who maybe are a little more methodical in the way they think, so that they don't just see that horrible video and make up their mind.
Potential jurors have to fill out a 14-page questionnaire describing how much they know about the case and their opinions towards law enforcement and Black Lives Matter.
I think they could probably just look at the questionnaire, look at some of the responses and think, okay, we have some that are really extreme on one end, the pro-BLM side, and then the pro-police side. And some of them, I think, could just get tossed. They wouldn't even have to waste their time bringing some of the jurors in. Of course, people know about the case. Of course, they've seen the video at that point. Then they have to really dig in deep and try to determine whether or not somebody, yes, you can still pay attention to the news, but not have a vested interest.
For the defense, Turkheimer suggests pretrial strategies like focus groups, mock trials, and venue attitude surveys.
If I was working for the defense, I would say, hey, here's a videotape, some videotape of the officer, Chauvin. Let's hear his explanation, and let's get some focus group reaction to it. Hear what these people have to say, what they expect. Do they believe him? Do they like him?
Turkheimer says both sides need to look out for people who have hidden agendas and are intentionally trying to get on the jury, also known as stealth jurors.
You want to make sure you don't have anybody who seems too eager to get on, but it's really tricky because these stealth jurors tend to know what to say to get on. They tend to moderate or temper their answers. They know to say they should be fair and impartial. So you have to take a holistic approach.
Jury selection is scheduled to take 3 weeks. Opening statements are set for March 29th.
It's going to be a challenge. I think they can do it, given that they have all this time to pick a jury, but it's certainly going to be a real challenge.
Michelle, you're getting first crack at this, being a jury consultant yourself and a person who's tried a lot of very high-profile cases. Well, I asked you earlier about what employment or profession a person is in. I don't know why I'm thinking as a defense lawyer, I want somebody who's in like the field of science or accounting or very, very specific and precise fields that deal with mathematicians, because you got a lot of moving pieces here and a lot of subjective interpretations. That's number one. And number two for you, what do you think about that concept of focus groups if you were on the defense in terms of letting them see that video, listen to Chauvin, and see how they respond?
I think focus groups can be key in understanding what your hot button issues are. And I usually recommend and use them. And when I tried murder cases on the defense side, I had the opportunity to use them in some cases. And it was super useful for exposing people to some of those pieces of evidence that you're worried about and seeing what types of people react in different ways. And then using that information as a way to know who to get rid of and who you want to try to use your strikes on, or how you want to create questions that will help you get some of those people who are bad for you, as I always told my clients, for free, which is the for-cause strike. Someone who says, I can't be fair. But as this consultant pointed out, I think a great point is some of your worst people, some of your scariest jurors for either side are those stealth jurors, the people who want to be on the jury and who use that magic language of, I may have said this or I may have posted that, but I can be fair. I can set that aside. And what my question always was, and what always goes through my mind when they're saying I can set that aside, is where are you going to put it? Where are you going to put that bias that I saw posted on your Facebook in huge bold or some meme about, something really inflammatory related to this case? Where are you going to set that aside during this case? And that was usually my question.
Okay, Doc, what do you think about the idea of selecting jurors for the defense that are more in the linear aspects of professions like scientists and mathematicians and accountants and people like that, because they may be more exacting and less subjected, the theory goes, to the emotion of the video?
Yeah, the jury expert discussed, as Michelle said, trying to get someone who's a little bit more mechanical and connect the dots and have that level of objectivity and not get swayed by emotion. From a clinical perspective, that's usually someone that's not going to get overly anxious or overly stressed out and is going to be able to maintain an even keel in terms of how they go about listening to the evidence, processing the evidence, and then eventually deliberating. Because remember, there's a lot of minutia in this case in terms of cause of death, use of force, a lot of departmental procedures and policies from the police department that they're going to have to get their heads around. And so having someone like that who has that type of interest, or at least that type of background, is going to be a lot different than the stealth juror who, from a clinical perspective, is probably got a narcissistic personality disorder and loves the attention and wants to be there more for the notoriety than performing their community service.
Okay, excellent analysis, guys. Let's listen to some of the jurors, or at least one of the jurors, on their perspective with regard to drug use, and because that's something that definitely is going to come into play in this case. Let's take a listen.
Sir, I was wondering if you have any close friends or family members or someone you care about who's ever struggled with illegal drugs.
I do not.
You do not. Do you have any opinions about people who may have used illegal drugs?
I mean, I think, I think it's a hard question. I mean, I think people use illegal drugs for multiple reasons. I mean, athletes are using it. People use it for recreational purposes. It's legal in some state. So I think, I mean, I don't think my opinion matters really, how I feel about it.
And when I'm talking about illegal drugs, maybe I'll even say drugs not including marijuana, but harder drugs.
Oh, okay.
Do you have any strong opinions one way or the other about the use of illegal drugs?
I mean, I know that we all know the impact of opioid, and obviously, it can impact people's life, and mental health is there. So I believe that us as a society, we need to look out for people who are struggling with those. Yeah.
So, Michelle, is part of the defense in this case going to be, in your mind, that the officers are trained in how to recognize somebody who's under the influence of a drug and how they're acting and reacting, and they can be very calm and peaceful one moment, but the next moment they can literally become very violent? Do you expect to hear that testimony in this case?
I think that will be some of it. I mean, I think it goes along with the whole potential self-defense. They were trying to prevent, anything that escalated further or that was happening before, but that's really not consistent with what we were seeing in the video footage that we have. And so I think they are likely to make that type of argument, but I don't think it really makes sense with the evidence and the facts that I've seen so far. But I'm not sure, beyond the police procedure and some of the other points that we've already discussed, what else they can point to.
Yeah, Doc, I mean, Michelle makes a great point. You dance with the one you brought when you're a defense lawyer on a case like this. And of course, let's not forget that George Floyd was handcuffed. So, and that this officer Chauvin's got his hand in his pocket. I think that visual, that would be the one I would blow up, that they weren't concerned or worried about a thing. They weren't even in a defensive position. He was just leaning on that neck with his hand in his pocket as this guy's crying out for his mother. And then even after the guy stopped talking, he didn't put him in that side recovery position. But anyway, do you expect the defense will go there?
Yeah, absolutely. And I think the bottom line will be, what substances are we talking about here? I mean, I've worked on numerous cases where individuals lash out at police officers under the influence of methamphetamine, which is big here in Los Angeles and other places, where I ask the individual, do you remember striking the officer? And they're like, what? I struck an officer? Like, did you not read the police report? No? Well, you did. And so this whole idea of unpredictability as it comes to the specific substance and what that could potentially do to you in that moment and potentially make you violent, that's a long stretch in terms of what we're dealing here for the defense to then say, well, Mr. Floyd was under the influence of X, Y, and Z, and that made him excessively unpredictable. He's a tall, imposing man. The officers were in fear for their safety, and therefore they did what they did. And by the way, had their hands in their pocket and knees on him for over 8 minutes. And so it's just the math. I'm not very good at math, but if I had to try to do this equation, the math just doesn't add up, Bob, in terms of they're trying to say, to a potential juror in a convincing manner that this man was so unpredictable and so violent based on the substance that he was under the influence of, to an extent where they felt that they were in danger and they were defending themselves. It just doesn't add up. Visually, the video is a slam dunk in that regard.
Yeah, but I still think they're going to go there with the unpredictability because they got to do something. Anyway, guys, we got to take a quick break. We will be right back. It looks like court is resuming its session. Let's go back in. Well, it looks like they're there, but there's not much talking going on. So it gives us a little opportunity to look at one of the interviews that Anjanette Levy did with the cousins of George Floyd.
To people around the world, George Floyd is the man who died on video in police custody and became a symbol of a movement to push for police reform. To Tara Brown and Sharita Tate, Floyd is their beloved cousin.
I have so many memories because obviously we grew up together. He was always funny. He was a jokester.
Life changed forever for Floyd's family late last May when Sharita Tate saw a story on the news.
I saw that, and my first response was, this is so sad. I feel really sorry for this man's family. And then, of course, maybe 5 minutes or so later, I got the call saying it was Perry. So, I said, okay, how did I miss that?
The video went viral, sparking protests and civil unrest in cities across the country.
I don't think there's a person on earth who would have predicted that it was going to happen this way, like that it would affect the entire world.
For the last 9 months, Brown and Tate have been focused on getting to the trial.
There haven't been a whole lot of wins, per se, in favor of these kinds of cases. But I have to believe that this will result in a different outcome. Just the sheer way in which this has moved forward and the movement that has started as a result.
Derek Chauvin's defense maintains that Floyd died of a fentanyl overdose, not from Chauvin's actions. The fact that Floyd's drug use will be an issue is painful for the family.
We expect that they will make him out to be, somebody that he wasn't. Or, just to assault his character or whatever, just to give people a different kind of impression of him. We're not saying he was perfect.
And to remember their cousin, Tate and Brown have started the George Floyd Foundation.
We have the 3 tenets that we're really working on. That's social justice, workforce development, and youth services. It's kind of like anything that we can do that can, make sure people, he has a legacy of doing things that are positive within the community. And we've always been people that wanted to give back.
Excellent. Michelle, I want to talk to you a little bit. One of the cousins there talked about character assassination. We're seeing this more and more in trials recently. Can you talk to us a little bit about the evidence rules and when prior or other act evidence, which sometimes is prior bad act evidence, is and is not admissible in a trial like this, both for Mr. Floyd as well as Derek Chauvin?
Well, certainly it's an interesting issue as character evidence relates to the victim in this case, who is deceased and can't come testify and defend himself or his character. But to the extent often that it is admissible for related to the actual proving of the offense or a defense, sometimes that is where it might come in this part of the trial where they are only making the determination of guilt or innocence, because trials are bifurcated in criminal cases where the jury in a lot of states doesn't even do punishment. In Texas, they do, but they're just determining guilt or innocence. And then the second part of the trial, by either a judge and in some states a jury, they just determine the range of that punishment. But I think that's a really interesting question and an interesting issue also as it relates to Chauvin, because although he's a police officer, he also had a history as a police officer. And I believe he had been involved in several police officer involved shootings. And so, if he testifies or not, it will be interesting as to how that opens the door and potentially makes information like that admissible, depending on what he testifies about.
You just took the question I was going to ask you, right out of my mouth, is that he's going to take that witness stand. Right now, the judge is allowing 1 out of, I think, approximately 15 to 17 previous incidents, potentially 1. He gets on that witness stand. He may open the door for other stuff to come out. Excellent point, Michelle. Doc, what about that? We're not supposed to be doing trials by character assassination. That is what the evidence rules basically say. But how damning is that kind of evidence when it eventually gets in front of a jury? Does it really hurt Chauvin if the rest of his record comes out?
Absolutely, because if the defense's goal is to humanize him, how are they going to do that when they lay out all of these officer-involved shootings and prior use of force incidents? I mean, you're trying to humanize someone who potentially could come across as an aggressive monster.
Doc, I want to ask you. I'm sorry to interrupt you. I want to ask you that based on your assessment of Chauvin's record and him, what is he could get up there and come off like that. You can talk to them about not to do it, but you know, you're not going to change your stripes. What do you anticipate he'd be like?
I mean, I think he's going to be methodical. I think he's going to be he's going to try to come across as very calm, very composed, almost, you know, boring. However, most officers, when they testify, in terms of my observation, they tend to hide behind their badge. And I expect him to do that. I expect him to say that I was trained in a certain way. However, the more they roll out it's like death by 1,000 cuts. He's going to bleed. He's going to bleed on the stand. And any experienced prosecutor is going to take him down, and the juror is just going to watch it happen.
Michelle, real quick, how bad would you salivate to get Derek Chauvin on the stand and to be able to cross-examine him?
To be able to ask him questions about every minute that he had his knee on that man's neck, and every minute that he had an opportunity to let off, and I'm going to
have to cut you off there. Guys, thank you so much for being here. You did a great job. Mike O'Brien next. Stay with us.